We talked earlier about marijuana, medical marijuana, and what's happening there in the state. And I wanted to bring in the issue then of DUI and sort of where that stands when it comes to the issue of marijuana, David.
Okay, so marijuana, unlike alcohol, when you have alcohol, you have what we call a per se standard. So if you're above 0.08 blood alcohol level, there is a legal presumption that you're under the influence of alcohol. That does not apply to marijuana or any other drug for that matter. And just because you have a prescription for it doesn't mean you can't get busted for DUI. So look at it a different way. Look at it as if you had a prescription for Oxycontin, which is a very powerful painkiller, opiate. Just because you have a prescription for it and you're taking it pursuant to your prescription doesn't mean you can necessarily drive if it impairs your ability to operate a vehicle. So nobody should be mistaken by thinking, oh, just because it's somehow I've got a right to do it because I got a prescription for it, it doesn't mean you have a right to jump in a car and drive if it impairs you. So that's what the law is with regards to marijuana. How much in your system, that's never really been determined and is usually determined based on the facts of each case. So how do they find the marijuana?
Right.
They test you one of two ways. They'll either test your urine or they'll test your blood. Here's the difference. In the urine, the only thing that can be detected, and I don't remember the long name for it, but we call it carboxy-THC. Carboxy-THC is a metabolite of THC, which is when your body ingests the THC and it is processed by the body, it turns into this carboxy-THC, which is what they can test for 30 days. You know, where employment testing, that carboxy-THC, if you put that in a bottle or in a pill and you drank 10 gallons of it, nothing, because it's inactive. The active portion of it has already gone. So the only thing that an officer would be able to tell, or a prosecutor or a judge would be able to tell, is that you have previously ingested marijuana. Now, a blood test will separate THC and carboxy-THC. So a blood test will tell an officer or a judge if there's active THC, it'll say that there's active THC, and now there's also this carboxy-THC. So, you know, I mean, if you haven't smoked in 2 days, probably best to take a blood test because it'll show there's no THC in your system. But again, it's a case-by-case basis, and there's no way to give general information unless you actually talk to the person who's been arrested and who is making those type of decisions.
Well, and is there a way to test for the percentage of, because there's a BAC level with alcohol, is there a standard for marijuana?
Well, there's no per se standard. So, but they can test, just like in any drug test, they can test up how many nanograms per milligram there are in your system. And then it's up to the judge to decide whether, based on the testimony of the police officer and the other circumstantial evidence, whether or not you're under the influence.
So when we're talking about even a field test, when can someone have an attorney present?
Okay, so most people think of Miranda. They think, you know, and that when it comes to Miranda, if you are in custody, not free to leave, and you're subject to custodial interrogation, they have to read you your Miranda rights. You have the right to remain silent, all of those rights that we hear all the time on TV now. Hawaii also has a statute, Section 803-9 of the Hawaii Revised Statutes, that gives you the right to an attorney. And that case was just decided, and it clarified a lot of misconceptions. So what this says is you do have a statutory right to an attorney, but the police don't have to advise you of that. It has nothing to do with Miranda. Miranda is a constitutional issue. This is a statutory issue. I believe, and we will get into more constitutional issues on some appeals we're dealing with, but if you ask for a lawyer, they've got to get you one. Now, the big question is, if you ask for a lawyer and they can't find you a lawyer, how does that affect whether you take a breath test or a blood test? Now, if you're not arrested, in other words, you're still in the field and they're doing the field sobriety maneuvers in the field, you always have a right to refuse those. So it's not a matter, if you called me, I don't care what the circumstances were, I'd tell you to refuse them because there's all kinds of reasons why you might not pass those field tests, including being very, very nervous. So don't make statements to them. I mean, don't be obnoxious. If they want your name, if they want your license, give them your license, give them your name. But you don't need to make statements about your case, about how much you've had to drink, about where you were, those kind of things. You don't need to make those statements. And as for the field sobriety maneuvers, as kind of a blanket rule, because most of them are not videotaped. I think there's one camera in all of the police force in one car, maybe two cars. Don't do it. If you think you're under, like you haven't been drinking or you had one glass of wine 4 hours ago and it's still on your breath, tell them you want a preliminary breath test. They'll have you blow into a little machine right there. But be careful because they can use that for probable cause also. So there is nothing compelling you to take these tests. And especially if you feel like things like ailments, sore knees, sore back, maybe you're just generally clumsy, can't do it anyway. Don't take it. Just say, I would prefer not to. I'd be happy to come to the station, and then you can make a decision at the station. And if you want a lawyer's help, when you get to the station, the law says you have a right to make those calls. The next problem is, if you get busted at 1 in the morning, there's not a ton of attorneys who are answering their phones at 1 in the morning. I mean, including me, I don't answer my phone 24 hours a day. But, you know, you do have a right to it, and so you need to speak up, though. Unlike Miranda, they don't have to tell you, you gotta speak up. Say, I want a lawyer. And they've gotta go do it based on what this case says.
All right, very interesting. Thank you.